Hi, this is Elena Sanchez Curtis, Vice Chair of the Equine Law Section, and we are very lucky to have today Dr. Tim Potter to talk to us. Briefly, Dr. Potter was born and raised on a farm in Northeast Arkansas, and he went to school. He completed his BS in animal science, his MS in physiology of reproduction, and a PhD in physiology of reproduction. He is a certified professional animal scientist, and he is actively involved in the animal industry. He also owns Potter Consulting, and he provides expert consulting services involving areas of animal science, including buying, selling transactions, appraisals, nutrition, reproduction, behavior, training, safety issues, abuse and neglect, facility design, construction, and facility maintenance. Dr. Potter, due to his expertise, has been involved in several areas of litigation, and he's going to share with us some of his experiences and wisdom. Thank you, Dr. Potter.
Well, thank you, Elena. I appreciate the opportunity to be here. Good afternoon, everybody. It's certainly an honor to be here, Elena. As you and I were talking, it was a simple email a few months back from me to you to introduce myself and so forth, and it established the communication between us, and here we are today. So I'm happy to be here.
Dr. Potter, I think people may be asking questions, and so if they would write them in the chat, and then when you're done with your presentation, if it's okay, we'll go through those questions.
Sure, absolutely. We can be here as long as there's questions to be answered.
All right, excellent. Thank you.
So yeah, I'm really pleased to be here. You can go ahead and put up the first slide, Lane, if you would. Whoops, that's the last one. That was quick. So I've as Elena talked about my education and experience and so forth, I've been involved in the equine animal industry for all my life. I've been doing consulting work for almost 20 years now, and have been doing expert work in litigation for about 10 years. So I've done roughly 150 cases, give or take. As a general running average, it's somewhere in the neighborhood of 60-40 plaintiff defense. So that's kind of where we are. If you go to the next slide, please. I get the question a lot of what is equine science, and basically it's just the study of all things equine. We talk about biology, behavior, care, anatomy, physiology, genetics, but what we try to do, and especially in litigation, what we're trying to do is apply these principles to the litigation process. to assist in various areas. Equine science, at least in my definition, includes everything, anything related to equine, with the exception of veterinary medicine. Now, that's not to say that I haven't done some veterinary defense cases, but if it's a case involving something pharmacological or something from a treatment standpoint, then certainly that's beyond the scope of my expertise. But pretty much anything else related to equine applies. Next slide, please. I put this slide up intentionally, obviously showing a dressage horse on the left, a reining horse on the right. And in terms of the types of consulting that I do and the types of expert work that I do, the breed and or the discipline really doesn't matter. Yeah, when we talk about safety, when we talk about horsemanship, obviously there are some small nuances or differences between the two in terms of the way that the horses perform and those types of things. But the basic premise of equine science applies across the board. I remember a case that I had early on. It was one of the first cases that I had, if I recall correctly. And it was a excuse me, it was an incident that had occurred at a hunter show. And so opposing counsel in my deposition goes through the questions, Dr. Potter, have you ever ridden a hunter horse? Yes. Have you ever trained a hunter horse? Yes. Have you ever judged a hunter horse? Yes. Have you ever shown a hunter horse? And my answer was no. And so as a result of that, I believe the attorney told me they filed a 180-page motion to try to get me kicked out of the case. And my position is when we talk about such things as safety and horsemanship and nutrition and feed formulation and all those things, that it's the same. Next slide, please. We've mentioned a couple of times basic horsemanship. And in doing a lot of these cases, it's a little bit of a shock, and it's really not at the same time. Of when we get into some of these cases, that the very minimal amount of just basic horsemanship that people are being taught in a lot of environments. Safety, things such as proper tack and equipment, and thinking about the fight or flight response and blind spots with horses and those types of things, really come into play. Behavior and training. How has a horse been trained? Has the training been done appropriately? Because a lot of people don't understand. And in classes that I've taught for over 35 years in universities, people need to understand that horses learn by association. They don't have the ability to reason, and so the training has to be very consistent. Here's a great example of a case that I had where a horse that had a demonstrated history of being difficult to mount. And when we got into the facts of the case, we found out that when this horse would be difficult, whatever that means, at the mounting block, that they would lead the horse twice around the mounting block and bring the horse back and give him a treat. Well, from a training standpoint and from an associative learning standpoint, we taught the horse to be difficult. So we look at things like that. Containment and confinement. I do a lot of those cases where horses, I've had cases with horses, with cattle, with other species that get out, that get off the property and cause some type of a vehicular collision. Nutrition, feed formulation, contamination. I've done a few feed contamination cases, and I can tell you that there's a lot more of those out there than the public are aware of. The bigger companies, typically you're not going to have as much issue there because they've got dedicated lines in their production facilities in terms of making equine or formulating and producing equine feed. But some of the smaller regional companies don't. And so in fact, I've done 2 or 3 now, I think, pretty big contamination cases. Veterinary issues related to management. I talked earlier that if it's something that involves something pharmacological or from a treatment standpoint, that's certainly not my expertise. But I've done a couple of veterinary defense cases. One was an alleged improper insemination of a mare, and another was alleging that the veterinarian missed a hairline fracture on the pre-purchase exam. And so cases like that involving veterinary issues would certainly apply. Buying and selling transactions, I'll sort of group that along with appraisals because generally those go together. Um, uh, a few cases related to the role of the different parties in the buying selling transaction, and then ultimately what those horses are worth. And Elena and I talked a little bit earlier before we went live about what a horse is worth, and so and I'm also am a certified appraiser, so I do several of those. Okay, next slide, please. I'm preaching to the choir here, I'm sure, with you all, but interestingly enough, I've been asked a few times over the years in depositions about really what my role is, and as you all can see by looking at this follows very closely with Rule 702. We're here to assist the triers of fact. You know, we bring our education, training, experience. We utilize the scientific method, and we prove or disprove elements of causation, notice, and standard of care. In some places, the term best practices is used as opposed to standard of care. And then we base those opinions on facts and support those opinions with accepted equine industry treatises. I've opposed several experts over the years that, for example, they would talk about industry standards, but they wouldn't tell you what they were, and things like that. So I'm very cognizant of Rule 702 and how to proceed in a particular case. Next slide, please. Okay, limited liability statutes, and let's go ahead and go to the next one. We've got, as we sit here today, there's 48 states that have some form of limited liability legislation as it relates to equine. Here in the state of Kentucky, they've cast a little wider net to include farm animal activities in addition to equine activities. So we have to, I have to deal with that issue in nearly every case. There's a dangerous assumption, in my opinion, that some people in the equine industry have as it relates to this limited statute. And that assumption is we have this statute, I can't be sued. And that is certainly not the case. And we typically, what I will do as an expert, it's beyond my scope to opine about a statute as a non-attorney, but I can certainly I can and do use the limited statute to establish the standard of care. In most cases, and I make it a point not to be very familiar with the language of the statutes, but the general exceptions in terms of the statutes are: number one, improper matching of horse to rider. Two would be improper tack and equipment, use of tack and equipment. The one that really plays pretty heavily in a vast majority of these cases are improper instruction, and that's usually in a lesson environment or a trail riding situation or something like that, where there's very little, if any, instruction that comes along. And then the fourth would be what you all as attorneys would define as something that's willful or wanton. My definition of that as an expert is something that would be intentional. I just had a case that we didn't get very far into it, actually, and it settled, and it was a situation where a beginner rider was in a riding lesson, and she was having issues with the horse, and the instructor had her do two things, which kind of mortified me a little bit. One, to take her feet out of the stirrups. She was on a lunge line. Take her feet out of the stirrups and then cross her arms in front of her. So she has nothing except sitting there. And then to make bad matters worse, the instructor goes and hits the horse with a crop. Um, so um, I think my client in that case played the willful and wanton card pretty heavily, and we actually got it settled early on before we got very far. Next slide, please. Okay, I want to talk about some different cases, and I put this up here hopefully to get a chuckle out of you, but also to tell you a story about it, and I'll actually talk about that when we get into one of the cases. But you didn't get bucked off, you fell off, and I've got a horse that can teach you the difference, and there is a world of difference between the two. Okay, let's go talk about the first case. This was a plaintiff case, a trail riding incident. We've got a beginner rider. The rider sustained a traumatic brain injury. We dug into the statutory exceptions. We talked about violations of best practices, and the jury awarded $3.38 million to the plaintiff. Let's go to the next slide. I just got a picture here of a trail ride. I can tell you, folks, that in over 40 years of teaching horsemanship and safety and teaching university classes and seminars and in every arena that I've been in, that whatever I've ever taught in terms of what needed to be done in to promote a safe environment for especially for a beginner rider was not done in this case. It went to trial, and they played some video clips from the defendant's deposition, and so they would play the clip and have me respond, and I'll tell you just two or three of them just to give you an idea of what we were dealing with. Remembering that the exceptions were, or the exceptions to the statutes generally are failure to match horse to rider, improper tack and equipment, improper instruction, something willful and wanton. We got three of the four. I got three of the four of those for sure. I think the first clip that they played, they asked the defendant, so why is it so important to match the horse to the rider? And the defendant actually laughed and said, so I don't get sued. And so I can see the jury out of the corner of my eye, and they're a little alarmed about that. And then there were a couple of clips that they played that were really pretty damning in terms of this case. The first one was, what was your assessment of this group when they arrived? And it's a quote, and I'm not gonna actually say the quote. It was a cluster, you know what? And they weren't paying attention and they weren't listening. And so they go back and they say, Dr. Potter, what's your assessment of that? And I said, well, in 42 years of teaching horsemanship and safety and so forth, have I had groups that didn't pay attention? Sure. In that scenario, the instructor has one of two options. You either get their attention and make sure that they understand and can demonstrate those instructions, or option two, send them home. So, I mean, and basically the instructions were, here's how you go left, here's how you go right, here's how you stop. And that was pretty much the extent of it. Tack also became an issue because the saddle was too small for the horse, and there were some behavioral issues that came into play. The thing I think that really got the jury in this case was when they asked the defendant, so what, excuse me, what type of horses do you bring into your trail riding program? He said, well, most of them are older, they're lame, they can barely walk. And there were certainly some raised eyebrows with the jury there. I was asked about my assessment of that, and I said, you know, in my experience and in my experience of judging horse shows for over 40 years, it's not acceptable in any circumstance or any environment to use a lame horse. Well, Dr. Potter, why is that? Well, it's abusive to the horse, number one, and it's dangerous for the rider. So um, that was probably one of the most extreme cases of non-compliance with industry best practices that I'd ever dealt with, and it was interesting to say the least. Next slide, please. Excuse me. This was a horse, and this was a case that was, this may have been, I think it was the first animal vehicle collision case that I did. The plaintiff was driving to work early in the morning. The horse had gotten out, was on the highway. Collision occurred, driver killed. There were fencing issues and behavioral issues. If we can go to the next slide, then I'll talk a little bit about that. When I do cases like this, we generally, well, for a horse to escape, for an animal to escape, there's generally a defect somewhere. So what was determined here was that these horses were brought onto this property late in the afternoon, and that's important. They were brought late in the afternoon and put into an arena with some cattle. Well, the industry best practices, and certainly what I've taught for many years, say that if you're going to introduce animals to a new environment, you need to do it at a time of day where they've got a chance to get themselves acclimated to find the fences and so forth. But these horses were stuck in the arena with the cattle. The corral panels were not secured properly, and more likely than not, what happened there became some behavioral issues and some dominance issues between the horses and the cattle, and they more likely than not, the cattle ran one of the horses through that panel, and there was no perimeter fencing beyond that. And so the horse wound up on the highway, and unfortunately the driver was killed. Next slide. This was this was a fun case. Defense, daughter versus mother. Plaintiff was an experienced rider, had ridden the incident horse multiple times. Horse described as dangerous. Did a site inspection. Assumption of risk certainly came into play. And then the jury came back 50-50, which was sort of a shock. But most of them voted that the mother didn't contribute. Go to just to the picture slide now, and I'll tell you more about this case. So when the client called me, of course he's defending mom, and one of the first things that he said, well, mom says that she just wants her daughter to get paid. And I said, well, you know, that's okay, I guess, but you know, if I was injured there, would it be the same? He said, well, probably not. So we got into it. It went to trial. And now this thing about the falling versus being thrown came into play. We went to, well, first of all, I did a site inspection. Well, let me back up. First they deposed me by phone. Then I went and did a site inspection. The horse was the incident horse was a gelding. I go to do the inspection and to evaluate this horse, and I so he was in a paddock that day with a mare, and I asked, can I go in with him? And of course, this is at Mom's place. Oh no, he's dangerous. Well, folks, I can tell you, I've had the unfortunate task of having hold of dangerous, and this horse was anything but that. But did as much as I could in relation to what I was allowed to do and where I was allowed to be for the inspection. So we get to trial, and it was very contentious, which was a little surprising to me. I mean, I've only had in all these cases, I think I've only had 4 trials, because most of them settled before that, but this one went to trial. And so one of the first things he said was, he said, well, Dr. Potter, I think you inspected the wrong horse at your site inspection. Did you? No. Well, how can you be so sure? I said, well, the incident horse was a gelding. He was in a paddock with a mare, and I don't even know what color she was, but the gelding is who I evaluated. Well, how can you be so sure? And Elena, we talked earlier. This was a non-equine attorney asking these questions, and he said, "Well, how can you be so sure?" And I said, "Sir, I've got a PhD in equine science. I know the difference." And probably the response that I'll remember for the rest of my life was the next question when he said, "And he was a gelding," and he was a gelding, and I said, "He still is." Um, so it just kept getting more contentious and more contentious, and at that point he was virtually screaming. And he said to me, he said, I asked you in your deposition if you'd ever fallen from a horse. And I said, no, you didn't. I said, you asked me if I'd ever been thrown from a horse, and there's a world of difference. But it was an interesting case. I mean, it came down to, you've got a rider here that's been riding 25, 26 years, has been on this horse multiple times. So, I mean, it was a very clear assumption of risk. Now, obviously, if that's a beginner rider, it's a completely different scenario. But in this particular case, it was assumption of risk. And what my client told me when they came back 50-50, he said they just wanted to be done. So so that's kind of the way that one played out. Okay, next slide. This was a huge case. Buying and selling transaction. The agent was the trainer for the plaintiff, and the agent was not a veterinarian. That's very important. And it was alleged that the agent didn't communicate the results of the pre-purchase exam to the plaintiff for 2 months. Then we obviously talked about the role of the agent, and then somewhere deep in the throes, we found that what they had alleged relative to the PPE was not correct. Okay, let's go that next slide. So in this case, this was a show jumper that was purchased in Europe. Um, if I recall correctly, the purchase price was somewhere in the 1.2 million range. Horse brought to the States, and so forth. In the trainer who was serving as the agent, basically, his role was to get all the parties together to get the veterinarian in Europe with the veterinarian in the States, and so forth. Um, and they alleged that when the horse got here, that he was lame. But when we started looking at the records, and there were I don't even remember how many hours on this case. I want to say it was somewhere in the neighborhood of 80 hours or so. But there were just mountains and mountains of information. But once the horse got to the States, this horse was still participating in jumping classes the 1.4 range, kind of in that category. And as most of you all well know, it's going to be very difficult to do that with a horse that's got any type of lameness issue. But then one of the things that they really tried to go after was that this agent did not communicate the results. And I was able to talk about that as a non-veterinarian. That agent, in my opinion, it's certainly what I've been taught, what I've taught, and there's industry sources out there to support it, that if the agent is not a veterinarian, then they should not communicate those results. It should be vet to vet. And so that was a long, drawn out discussion during the deposition and so forth. But then we get back to what they primarily alleged, was that they were not provided the results of the PPE for 2 months after it was completed. And deep in the throes of all those documents, there were some WhatsApp messages, and guys, I'm pretty old. I didn't know what WhatsApp was before this case, but there were some WhatsApp messages in there that showed that the results of the PPE were in fact communicated the day after the PPE was done. So that was pretty much game, set, and match for them. I think they got that settled pretty quickly. I believe, I don't know this for sure. I think there may have been some discussion about potential sanctions and things like that against not only the plaintiff but their attorney. But it was a huge case, and there were some damages calculations and lack of that went into it, and a few things that would lean toward the appraisal side. But just a really big case, interesting case. So those are, next slide, I think, is our last. Those are just 4 examples of the many types of different cases that I've done over the years. Certainly in every case, there's some applicability, and there's some application of principles of animal science when we get into this, whether it's management, whether it's behavior and training, safety, whatever the case might be. I remember a case that I did one time, and it was involving racehorses, and they were alleging that this horse wasn't fit to race. And my response to the attorney in our scoping call is, well, that can mean a lot of things. That could mean physical training, it could be or physical fitness, it could be nutrition, it could be the way the horse is shod, it could be the innate behaviors of the horses. It could be a lot of different things. And I think his response was, I know very little about any of that, you're hired. So with that, I mean, it's like I said, this is just a very much hit the high points, of the type of cases that I've done, and then just the way that these various principles come into play. I mean, there have been lots of cases, whether it was with a non-equine attorney, which there's been a lot of those. But even working with equine attorneys, there's been a lot of times when just in discussions between ourselves, have you thought about A, B, and C as it applies to this case? And so that's kind of where we are, and that's what we do. Again,
Right. I was going to say, does anybody have any questions? I don't see any appearing in the chat, but if you want to type them in, I do have a question.
Okay.
Dr. Potter, how important do you think it is for an attorney to understand equines and horses when representing either a plaintiff or a defendant in an equine law case?
Well, I think it certainly helps. Um, you know, it certainly helps because I've done, I don't know what the percentage would be, but a large number of cases with attorneys that you know, and I say this lovingly, that can't spell horse. Um, you know, and so that it's there's a lot of education that has to be done, you know, on the front end. You know, when we're talking about things that you know, for us horse people, I mean, it's just pretty common knowledge. You know, it's things that, you know, if we've been in this long enough, that it's kind of instinctive. You know, we really don't have to think much about it. You know, one of the biggest things that I had to really work on, um, and this really applies in working with non-equine attorneys, is when you know, when I would be talking with them, or when I'd write a report or whatever, I've got to I can't I need to simplify it as much as I can. You know, I mean, obviously it's still scientific, but it's got to be pretty simple, and especially if it's going to go in front of a jury. Certainly, my preference would be to you know, to work with attorneys that have a good understanding of equine science. Um, I've done it both ways, but it's certainly more helpful, and it's more time efficient, I think. You know,
I have, I don't, Lane, I don't see any other questions, but I do have a follow-up question. In my experience, when you're trying to bring a med mal case against a veterinarian, we in Georgia have to have an affidavit from another veterinarian saying that the standard of care was not met or insufficient or substandard. My experience has been it's very difficult to have another large animal vet. I think maybe because there's so few, say something negative about the vet that you
yep.
want to sue. Do you have access to other equine veterinarians who are willing to write those affidavits?
That's really a two-pronged question. I have access to obviously to some equine veterinarians. I don't know with the vast majority of them if we've ever had that conversation. So I don't know that I'd be comfortable in saying, oh, sure, I can, you know, I could tell you, you know, these two folks would do that. And I mean, and I understand where they're coming from.
Mhm.
You know, but at the same time, I also recognize the importance of having you know, having a peer you know, that would provide you know, an affidavit, an opinion like that. So yes, I have access to them, but I'll certainly have to ask a few of them. You know,
Okay.
how do you feel about that? I would suspect, um, and don't hold me to this, but I would suspect that their attitude is going to be, well, you know, just how egregious was it?
Right. Right.
Um,
Okay.
you know, so
Thank you. Are there, Lane, I can't tell, are there any other questions?
I don't show any questions at this time.
All right. Does anybody have any questions for Dr. Potter? If you would like to unmute yourself and ask.
sure. I mean, we could.
No? Okay. Well, Dr. Potter, I very much appreciate you spending the time with us and going through these cases. I think it's been very helpful, at least for me, since probably 30% of my practice is equine law. And if you want to, I think everybody has your contact information. And so if anybody needs to reach out to Dr. Potter, please do not hesitate to do so.
Yeah, feel free. I'm available. I mean, you can reach out and I travel some, but I will respond to any request no longer than 24 hours.
All right.
And most of the time it's much quicker than that. So anytime you've got a question, or if you just if you have something you feel like you just need to bounce off of me, I'm perfectly willing to help.
All right. Well, thank you for your time, and thank you to all the participants for joining us today.
Thank
Thank you,
you.
Lane.
This concludes today's meeting. Thank you for joining and have a great afternoon.